Good afternoon, and welcome to Tiller House. My name is Elizabeth Anderson, and I'm the Executive Director of the American Society of International Law. It's really a pleasure to welcome you here today for this very timely discussion of law of war detention. I want to say a word of appreciation to the Open Society Institute, which supports the Society's work at the intersection of international law and security issues, and we're very grateful for that. And we are also, we benefit in that area by just terrific expertise on the law of war in particular, gathered in our Liber Society interest group on law of war issues. And we have to thank for today's program the chair of that Liber Society, Dick Jackson, who's here and going to moderate today's program. Dick is the Special Assistant on Law of War Matters at the Department of the Army when he's not working for ASIL on Liber Society matters, and a real great asset to us. I want to say another word also about the upcoming ASIL annual meeting. There's a brochure on your seat, and there are materials on the website about the program. This year's co-chairs of the annual meeting had the foresight to put Dick on the program committee. So if you like today's program, I can assure you there's going to be lots more of that kind of fare on the annual meeting program. And just to whet your appetite, I'll read a couple of the titles of sessions. There's going to be a program on commissions of inquiry into armed conflict, breaches of the law of war, and human rights abuses. There's going to be a program on integrating the crime of aggression into international criminal law and public international law. A program entitled New Battlefields, Old Laws, Shaping a Legal Environment for Counterinsurgency, and one entitled International Legal Implications of Israel's Attack on the Gaza Aid Flotilla, just to name a few, plus a plenary with Assistant Secretary of State Mike Posner talking about U.S. engagement with the Human Rights Council, a plenary of general counsels of different agencies of the U.S. government, including the General Counsel of the Department of Defense and the Department and the Central Intelligence Agency. So lots of good stuff there, and the early bird deadline for registration expires this Friday. So get on that, and if you work either for the U.S. government or any government or international organization or for a non-governmental organization, there is a discounted rate of $125 for the meeting, and you can see me or any of our staff to find out about how you get to take advantage of that. So without any further introduction or sales pitch, I'm going to pass it off now to Dick to introduce today's session.
Thanks a lot, Betsy. I'd also like to add my thanks to the Open Society Institute and to ASIL for sponsoring this, along with the Liber Society interest group of ASIL. First, I'd like to just go over our agenda, or how we're going to handle this panel. I'd like to give a brief introduction into the issue and the current state of the law. Now, I'm here as the chair of the of the Liber Society, and in my personal capacity, I'm not here as the law of war expert for the Army. So what I'd like to do is just set up the panel and ask some questions of our panelists. And but first, to get started, let me cover where the law is now. The law of war-based detention really goes back to first the authorization for use of military force, but then the executive order from the President of the United States, or vice versa, from President Bush. And then it was superseded essentially by the executive orders of President Obama in January of 2009. Now, those executive orders in 2009 did a couple of things. First, it mandated a review of the standards of the detention at Guantanamo. And second, it mandated a review of each individual case. And that second panel, the second board, was responsible for determining whether individuals would be transferred, prosecuted, and there was a deal worked out between the Department of Defense and Department of Justice on whether or not the prosecutions would be a protocol for determining the prosecutions between military commissions and federal courts. And then finally, that panel would recommend long-term detention if necessary. that the panel came back with a recommendation for about 48 individuals to be retained long-term under the law of war. So what does that mean? On the 13th of March of 2009, the administration filed a memorandum before the court for several habeas cases in which they cited the authority for detention back to Hamdi and the authorization for use of military force as informed by the laws of war. Well, what does that mean? What is detention informed by the laws of war? The laws of war don't essentially authorize detention. What they do is they describe the parameters for detention, the way that an individual would be detained, and for what purpose. In the Geneva Convention for Prisoners of War, they describe detention that's for the duration of the conflict. In the Civilians Convention, they describe detention for imperative reasons of security. But as the Hamdan case said, we're not in an international armed conflict. So the Geneva Conventions, by their terms, only apply to a international armed conflict. So informing this detention by the laws of war really means drawing analogies from the law for international armed conflict detention and applying it to the detention in this case. We have another couple of developments recently. There's at least one bill floating in Congress dealing with the parameters of that detention and that describes the parameters for the detention and who may be detained. And there's been public reports of a draft executive order out that has not been released yet, to my knowledge, that may also describe the parameters of detention. Now, there's also been a lot of great writing on this subject, and the four members of our panel have provided some of that, but I'd like to draw your attention to a couple. Chris Jenks and Eric Jensen put together an article on indefinite detention under the laws of war that talks about due process and the treatment standards for detention. Bobby Chesney, who with Ben Wittes put together a great article analyzing the habeas cases last February on al-Bahani and the other habeas cases, has an article that's on SSRN right now called Who May Be Held? Military Detention Through the Habeas Lens. And Walter Kuhn, who works on the Senate Judiciary Committee, has written an article that's also available on SSRN called The Terrorist Detention Review Reform Act, Detention Policy and Political Reality. And of course, Ben has also just published a book on this topic that's called Detention Denial, The Case for Candor After Guantanamo, that's available from the Brookings Institution Press. Joanne has written with Human Rights Watch before her current job a great deal on this issue, as has Lori Blank in op-ed pieces and with Amos Giora. And as I said, Eric wrote on the issue of the parameters of detention. So what I'd like to do is pose a series of questions to the panelists to go over whether or not we should engage in law of war detention, under what circumstances, what process of review should be available for those detainees, whether or not the executive, the legislative branch, or the courts, or a combination of those should be making those rules, and to talk a little bit about the procedures and treatment standards that come with law of war-based detention. First, Ben, what do you think the policy basis is for law of war detention, and why is it better than law enforcement detention? And second, what should be the parameters of that detention? Who should they be? Where should they be picked up? Or should it matter geographically where they were located? What review process is involved? And what do you think about whether or not the courts, the executive branch, or the legislative branch should be involved in this?
So I'd love to do this. Oh, I was going to say I'd love to do this without the mic, but here it is. Thanks for the introduction. So this is this question of whether and when and under what circumstances detention is, I think, actually very timely, and I think we should actually start by disaggregating these questions a little bit, because one of them, I think, gets dramatically too much discussion and too much attention, and the others get dramatically, as a consequence, too little. And so I think in our broad discussion of detention, we have three tiny tails that wag one giant dog. And I want to discuss and dismiss the three little tails very briefly, and then talk about the dog. For those of you who were at Harvard on Friday and heard me give this very same talk, I apologize. I see two of you, and I feel bad about it, alas. The first tail that wags the dog is the question of the per se question of detention. We have this endless, earnest argument: should we be engaged in non-criminal detention, or should we not be engaged in non-criminal detention? And I have a very simple message for you, which is whatever you think about the right Platonic answer to that question doesn't matter. It's a decided issue. We are engaged in non-criminal detention. We have been engaged in it for 10 years, now 9 years. We are going to be engaged in it for the next 9 years. The Supreme Court has no problem with it. You can focus on dicta that seem to suggest otherwise, but I'm telling you, there's no appetite in the Supreme Court for saying you can't do it. The Congress of the United States has never raised its voice in objection to this, and presidents of both parties have insisted upon its propriety and necessity. So you have a consensus between the branches of government that this is going to be something we engage in. Get used to it. It's the world we live in. Second tail that wags the dog is a place. It's called Guantanamo Bay. We fight endlessly about whether we should retain the facility at Guantanamo Bay or close the facility at Guantanamo Bay. It doesn't matter deeply, or rather it matters largely as a PR and symbolic issue. It has no substantive importance at all. If you are engaged in detention, the relevant question is when you are going to engage in detention, how you are going to engage in detention, what rules you're going to create for detention. The location of the policy is really an unimportant question. We focus on Guantanamo because it's so much easier to talk about a military base and whether it's a recruiting tool for the terrorists or whether it's keeping America safe. It's so much easier to talk in that language than it is to face very hard questions about the rules of detention. But it is actually a deeply unimportant question whether the location for your detention is Bagram, Thompson, or Guantanamo. So let's figure out, if you figure out the right answers to the questions that Dick asked, which I'm going to come to momentarily, the question of the location will really take care of itself. The third tail that wags the dog, and this one is a little bit, will be a little bit less bombastic and more tentative about it, is the question of criminal trial. We talk endlessly about the difference between military commissions and federal court trials, and which is legal and which is preferable and which has better security implications and which has better prospects for defense and for prosecution. The truth of the matter is that the numbers of people that you are going to bring to trial relative to the number of people that you have to detain is so small that this is not numerically a significant factor in how you resolve the question of your detention authority. So let me give you just a few numbers that will give you a sense of this. In the Guantanamo population alone, which is the only population that we've ever subjected to this particular rigorous analysis, the President's Task Force, about which you just heard, determined that of the 240 some odd people then at Guantanamo, 36 could be brought to trial in any forum. Now, I think it's 36. It maybe I may be a handful off in one direction or another there, but it was, mid-30s, okay? So this is not, now, so assume you could do them all in the forum of your choice. You still have a Guantanamo problem. Assume that, and this, of course, doesn't include any of the people we are detaining anywhere else. So no matter how you resolve the question of criminal trial, you still have a big detention problem to work with. So my submission is the following. We have over-discussed these three questions dramatically and under-discussed what is actually the important question, which is that given that we are going to be engaged in detention, we are not going to be able to resolve all cases of people we feel the need to detain by criminal process of one sort or another. And given that we will do some of this at Guantanamo Bay and some of it at other places, the question that we all need to stare ourselves in the mirror and ask is, what are the rules of that detention going to look like? Do we want to do it under the laws of war, or do we want to do some of it or all of it under some specialized law that you would want to develop for that purpose? And critically, who do you want to make those rules? These seem to me to be the two questions that we have very studiously as a society refused to answer. And there is a consequence of our refusal to answer it, which is that we've delegated it to a specific group of people. The specific group of people to whom we've delegated this question are a group of judges on the D.C. Circuit Court of Appeals. Now, the D.C. Circuit is an interestingly positioned body to make our national security policy with respect to detention. It's a group of people who just at a guess, I don't think any of them would have sought the responsibility. I think some of them are evidently bewildered by having been handed it, and some of them have expressed that fairly clearly. And I think there is a great discomfort evident in their opinions at the role that they've been given. But for those of you who think, well, that's not really the D.C. Circuit, it's the court system that's been given this role, be careful, because there's no sign of any interest from the Supreme Court in granting cert in any of these cases. A lot of the cases that the D.C. Circuit is deciding are narrow, non-cert-worthy technical questions that are, in and of themselves not very important. Important only in the accretion of them over time into what is effectively the creation of a system of detention, a significant system, a significant body of law that governs our detention while we all sit around and ask ourselves the per se questions. Should we be engaged in non-criminal detention? Should we close Guantanamo? While we're having this conversation, a system is being built. And it's a system that we are not participating in building because we're refusing to face the questions and we're giving them to the D.C. Circuit instead. So I'm going to stop there and happy to address any of these issues later on.
Great, Ben, but you focused on the per se questions and didn't answer most of my questions. So, but let me try with Joanne a little bit, and Joanne, I'd like you also to address the per se question, whether or not there's a policy basis for law enforcement detention. I mean, for law of war-based detention over law enforcement detention. But there's some dicta, as Ben described it in Hamdi, about whether or not law of war-based detention can continue as long as, or longer than the model which it was developed for. And you all recall the Geneva Conventions were written in 1949 after World War II. So that's the model the drafters had in mind. Although there have been prisoners of war kept for up to 20 years. The Moroccan pilots were held by the Polisario for that long. Do you think law of war-based detention can survive without any additional authority or additional description of the parameters, and should it, Joanne? And can you also address some of the other questions of if there is any administrative detention, what should be the parameters of that detention?
Okay. Okay, well, I mean, I agree with Ben that it's important to disaggregate a couple of cases here. And I think essentially what you're asking, and it's one of the questions the Supreme Court's Hamdi opinion invites, is can so-called law of war detention survive when you don't have a real underlying war, when you have a more metaphorical global war? And so, I mean, the two paradigms that I would like us to separate out, and which I think have been, they've overlapped in time and have been very easy to conflate, and very much to the US government's benefit in terms of its ability to justify some of the actions it's taken since September 11th. But the two paradigms are, one, traditional armed conflict, i.e. the armed conflict that we all agree continues in Afghanistan, which started obviously as an international armed conflict in which the Geneva Conventions applied fully despite, I think, President Bush's and other US officials' claims. It started as an international armed conflict to which the Geneva Conventions applied fully, and then with the Karzai government became a non-international conflict to which Common Article 3 of the Geneva Conventions apply, customary international law applies, and arguably elements of the additional protocols. But I think the Supreme Court, I mean, you said, oh, don't worry about it, the Supreme Court has upheld it. The Supreme Court clearly in Hamdi upheld the war, the detention incident to the armed conflict in Afghanistan, which is a traditional armed conflict. And yes, in dicta, Justice O'Connor said that she cast doubt on whether a situation, and I quote, unlike those of the conflicts that informed the development of the law of war. And I think very clearly she had in mind this claim of a global armed conflict with al-Qaeda, this non-state actor that doesn't resemble a traditional party to an armed conflict. And she suggested that the authority to detain in that circumstance may unravel. And yes, the DC Circuit has not yet found that the authority to detain has unraveled, even though it's been addressing cases that are very remote from the conflict in Afghanistan. But I think it's still an open question whether the Supreme Court would and should do so. And you can, yes, look at the current composition of the court and the votes in the various detention decisions, and you can be pessimistic if you're of my view and believe that they should strike down such expansive views of the power to detain. You can be pessimistic about whether that will happen, but I don't think that answers, I don't think that it's open and shut then that it's not worth discussing, and that constitutional scholars and international law scholars can't have a very different opinion from the opinion that we may pessimistically believe the court's going to issue. And just on that, and I think you had a story, I was looking at the news last night as I was thinking about this panel, and I was struck in the news about Egypt, and I saw an article that said that the US government is now laying down specific conditions to the Egyptian government in terms of dealing with the unrest. And it's calling on the Egyptians to immediately repeal the emergency law, which allows indefinite detention without charge. And I just found that so ironic and telling that this government is condemning Egypt for engaging in a practice that it engages in, and calling on Egypt to immediately take steps to stop something that, of course, Obama promised that he would do within a year and hasn't managed to do it yet. And, obviously there's differences between what we do at Guantanamo and what Egypt does. Egypt relies on the terrorism justification, but clearly they have detained many people who are simply government opponents. But still, I think the similarities are important to look at, and they haven't escaped the Egyptian government. And I think it's interesting to see that in the past decade, the Egyptian government has very often pointed to Guantanamo in justifying their own policies and justifying their reliance on the emergency law. And most recently, last May, when the emergency law in Egypt was renewed for the last time, the Egyptian government specifically compared their failure or their difficulty in replacing the emergency law with some other system to Obama's difficulty in closing Guantanamo. And I can just imagine now with the U.S. demands on them to close, to shut down their emergency powers, that they are saying, you know, to the U.S. government in response, well, why don't you close Guantanamo immediately as well?
Are you suggesting that we should have an emergency law of our own?
Well, I think many commentators, including Ben Wittes, believe, I mean, we have a system of indefinite detention. The question is, I think, at base, should it exist, or should we replace it with just try or release in terms of people who, you know, would otherwise be subject to the criminal justice system? And as I said at the outset, I want to clearly distinguish between the situation in Afghanistan, which is an armed conflict, and the situation of people like Ali Salah al-Mari, Ahmed Gailani, Abdul Muttalib, people who have traditionally been considered terrorists, have since September 11th in many contexts been labeled enemy combatants or alien enemy belligerents, but are people who the claims against them are that they're responsible for terrorist crimes. And in my view, the temptation to rely on administrative detention is simply a way to avoid the rigor of the criminal justice system and the, you know, the rigor of traditional criminal justice guarantees. And I just, to get back to the international examples, because I do think they're telling. One, it should at least, I think, give us it should be cautionary that if you look around the world, yes, there are democratic governments that have used indefinite detention, often to their regret. I mean, the British have, you know, used it during the emergence, the conflict with Northern Ireland, but clearly recognize it as having been a failure and having fomented unrest rather than having, you know, been an effective tool in dealing with it. But much more often, if you look around the world, it is oppressive, authoritarian governments that rely on indefinite detention. And you can almost, you know, it's such a hallmark of authoritarian governments. It's almost the more authoritarian, the more repressive the government, the larger number of people are held behind bars without trial. I don't think that's just a random correlation. I think there is something characteristic about reliance on indefinite detention that is attractive to repressive governments. It is, repressive governments don't like to be constrained by rules. Preventive detention, compared to the rigors of a public trial, is an open-ended, indeterminate, and extremely malleable process. It lends itself to abuse. I think even when the courts are deeply involved, which, as I understand it, Ben and others recommend, I think reliance on preventive detention still implies much looser standards in a criminal trial in almost every respect. If you look at everything from standards of evidence, openness to reliance on secret evidence, standards of proof, the rules become much more lax. And just to, you know, go back to the fundamental question, I don't think the case has at all been made that there's a need to rely on this new system, this alternative to the criminal justice system. And I think if you look at the record of the criminal courts, of the US federal courts over the past 9 years, and you compare it to the record at Guantanamo and of military commissions, it's clear that the federal system has worked much better. There have been, if you look at the Justice Department statistics or NYU Law School statistics, there have been hundreds of cases of international terrorism that have been prosecuted involving plots both inside and outside the United States. There have been complicated trials that some commentators are not entirely satisfied with the verdicts of, like the Gailani trial, because he was acquitted of some number of the charges against him. But in the end, I think in terms of the goals that we share of, one, incapacitating terrorists, they have been extremely effective. In terms of the goal of bringing justice to the victims, they've been extremely effective. And in terms of the broader goal of legitimacy, which I think in the end is an important goal, they've also been extremely effective, and they've, their record is much better, obviously, than the record at Guantanamo. Guantanamo carries with it an incredible stigma. It is a symbol, whether we like it or not. We may think that Guantanamo is different now than it was 8 years ago, and that's true, but it still carries with it a real stigma, and that's the stigma of... Okay, sorry. I'm just comparing the record of the federal courts to the record of U.S. reliance on indefinite detention over the past decade. And my point is simply that the record is clear, I think, that the federal courts have been much more effective in dealing with terrorism, and that the case, the empirical case has not been made that there's a need to rely on this alternative system to the criminal justice system. I'll
Joanne,
stop there.
if I could
Yeah.
interrupt for a second. For what I hear you saying, though, is that with respect to those that were detained in an international armed conflict, say members of the Arab Brigade that were detained in Afghanistan during armed conflict, that law of war-based detention is still appropriate for them?
The international armed conflict has ended, so at the end of the armed conflict, people are supposed to be repatriated to the home country. And the Al-Qaeda suspects that were picked up during the armed conflict in Afghanistan are now being held, essentially, I mean, we're using administrative detention as a kind of proxy for criminal justice detention, but with just less guarantees, fewer guarantees.
So because it's morphed into a NIAC with the same parties involved, for law of war-based detention, the conflict's over and terminated, and the provisions of conflict termination in the Prisoner of War Convention should apply?
Well, I guess let's be clear about the non-international armed conflict in Afghanistan involves the Afghan government and largely Taliban forces. Sorry. I don't, and I think many people don't accept this larger idea of a non-international, global non-international conflict between the United States on one hand and Al-Qaeda and associated forces on the other. The idea that there's an armed conflict going on in Egypt, in Bosnia, in Africa, and the U.S. can pick up people and bring them to Guantanamo and hold them under the laws of war. I think that is the situation that Justice O'Connor referred to in Hamdi, in which you're stretching the concept of armed conflict beyond its limits. And therefore, you're stretching the idea of law of war detention far beyond its limits. And as I understand it, actually, Ben doesn't necessarily believe that the preventive detention regime that the U.S. should create is really a law of war detention regime. I think you're more honest about the fact that this is preventive detention of terrorist suspects.
Well, I'd like to ask that follow-up question, too, to both of you, and that is, are either of you suggesting that there's a geographic limitation on where people are picked up that would cabin people for administrative detention or law of war-based detention to a certain geographic area? And a follow-up for you, Joanne, is with respect to criminal-based detention, do you recommend any changes to our pretrial detention regime in order to deal with this special class of criminals, as you call them? Why don't you start, Ben, with the parameters question?
Well, so I think any time you try to describe what's the universe of detention that we're engaged in under a single rubric, you're going to tie yourself in knots, because we actually have several detention systems that we are currently operating under a single rubric, and it doesn't really work very well. And so one of the things, as Joanne said, one of the things that I believe is that we should, separate different types of detention and do them pursuant to different authorities. So let's take, I think, the easiest case first, right, which is the group of people that when the U.S. military operates overseas, it is targeting. And when, in the context of what is now, I guess, a non-international armed conflict, right? And when it targets people, sometimes it has the option of, instead of killing them, capturing them instead. And it has the lawful authority to detain those people as the lesser use of force relative to killing those people. Now, I think those detentions are relatively uncontroversial. There aren't a lot of people who will stand up and make the argument that when you send fighting forces into combat settings and they capture people instead of kill them, that they should either prosecute them or let them go. That's not the way fighting forces work. It's not the way they've ever worked. And so I think, a fairly conventional model under Common Article 3, or if you want to think about it under, as combatants under Geneva 3. I mean, I'm not terribly particular about, I'm not an international lawyer, and, I don't have actually strong feelings about how you structure that. Some form of fairly conventional law of war detention governs that situation in practice, and I don't think there's a big theoretical problem there. So the second group of people where I think you do have a theoretical problem is the group of people which Joanne identifies. And these, of course, groups are porous. The borderlines between them are porous, and we need to be candid about that. And that's a group of people where, you can argue for purposes of the AUMF that they are part of the enemy, right? They are part of or supporting, to use the language that the DC Circuit applies, enemy forces, the Taliban or Al-Qaeda. But at the basic, if you really look in your soul and say, why are we detaining this person? We're not detaining them because he's the analog of the German soldier who's just kind of attached to, he's serving his country, or in this case, serving some non-state group with whom we have some division, political difference that's unbridgeable by means other than force. We're detaining him because he's a really, really scary guy who wants to blow things up, right? And we're detaining him because there's some individual fear of what he will do. Now, he may do that in his individual capacity, or he may do that in a capacity as member of the group. The more you can show the latter, the easier it is to think about it under law of war. But ultimately, what's driving that detention is not the same thing as what's driving a conventional law of war detention. And I think the more the further out that spectrum you go, the more it makes sense to think about that under a rubric of law that's different from the conventional law of war model, which is fundamentally not about the individual dangerousness of the individual detainee. The third group of people, and this goes to Dick's last question, are people who are more plausibly thought of within the criminal justice system than they are under non-criminal detention, but you need some grace period to figure out whom you've got. The criminal justice system is actually really bad at this because it's not something that in the normal course of criminal law you really need or want. But it's a situation that comes up in global counterterrorism operations all the time. So to give you two examples, Pakistani forces raid a safe house in Faisalabad. They capture a high-value detainee and 10 other guys who happen to be living with him. Too hot for them to handle, and they say, do you want these guys? We're not going to keep custody of them. Do you want them? And you've got to decide right then whether you're going to take custody of those people. You don't get to figure out whether there's a criminal case. Now, if you have no short-term detention authority, and you're only operating in a criminal justice mode vis-a-vis this group of people, you have no authority to take custody of those people at all. And so that's a problem that arises in this context that doesn't arise in a criminal context often at all. Another example of that would be, if this situation, the sort of crisis detention, you may not need a long period, but you often do need a short period. Again, the laws of war are not especially designed for that situation. They're not conducive to it, frankly, and I think the idea that you might want some supplemental authority that's tailored for that situation is commonsensical, frankly.
Joanne, would you address that third category do you think there needs to be any change to the criminal law detention model to deal with this class of individuals?
The third category that Ben referred to of people who are dangerous and should be subject to.
Or it should be subject to criminal law-based detention, but for a period of time to determine whether or not what you have, whether or not they're dangerous or susceptible to criminal prosecution.
Okay, the hypothetical that. Well, I mean, you can construct a hypothetical that leads to an obvious answer, but I haven't seen in reality that.
No, that's not a hypothetical, it's a real case.
Well,
That's the case of Abu Zubaydah and the group of people who were around him in Faisalabad in 2002.
well, then I think if you're talking about Abu Zubaydah and the people around him, then we're not talking about short-term detention, obviously, because these are people that have been in U.S. custody since 2002, I believe.
Be
he was
careful.
picked up.
Be careful. Some of those people, Abu Zubaydah
but
has been in detention
I
the
think
entire.
that very much shows the weakness of this claim that you can hold them for a short amount of time and then decide what to do with them. You know, we've gone down this road now of holding people indefinitely based on association, and it's sort of self-perpetuating, because when you've held people for years, it's very hard to then let them go and say, well, we're sorry.
But that's an argument about the contours of the long-term authority. The immediate question is, do you have any authority to take custody of those people at all? And if you want there to be some authority for that, does that authority reside under the criminal law, under the laws of war, or under something else?
For example, in the Fourth Geneva Convention, the Civilians Convention, there's the detention for imperative reasons of security. And then from human rights law, there's emergency decree-based administrative detention. Are either of those two means or a modified criminal law model available, or should they be available in your view, Joanne?
Well, I mean, there's the UK approach in which they've extended periods of pre-charge detention, I think, with the idea that you need to have a certain amount of time to investigate before you release dangerous people. I think it's interesting that the UK is now deciding to cut back. I think they're going back to 14 days from 28 days. But I don't think that's what we're talking about when we're, the cases involving people picked up in Pakistan. And there, I would again reiterate, and I think Ben agrees, because what you were the last, when you were describing the different categories, I think we were in agreement that there is a category of people in armed conflict where the laws of war apply, but this category of people who are dangerous, that are essentially, terrorists, that we are, or at least terrorist suspects, the laws of war don't fit them comfortably. So a law of war rationale, I mean, you're either using it just as a matter of convenience, which I think is what the Bush administration did. It gave you the outcome you were seeking, even if legally it really didn't fit. So you're using it disingenuously. And if that's the case, I think you're better off getting Congress involved, being honest about what you're doing, and creating a system that meets the necessity that you believe demands that kind of approach. But I do quibble with, or I do disagree with, the idea that the realities of the situation demand that kind of approach. And I think so far, if you look at our criminal justice system, we have managed much better than this reliance on administrative detention. So I mean, I think if you compare the record of the two approaches, the criminal justice approach has proven itself, and glaring weaknesses haven't been revealed. And I mean, look at the UK. They extended pre-charge detention, but they haven't relied on it, and now they're going back to it. And besides that, which is a incredibly minor, I think, change from traditional legal rules compared to what the U.S. has done, aside from that, they've relied on the criminal justice system, and they have carried out hundreds of prosecutions of suspected terrorists, and I think successfully. And if you talk to UK officials, they'll tell you, how this concept of war on terror is terribly misguided and has, it creates a terrible backlash in the Muslim world, and how their approach of relying on the criminal justice system has worked. So you can compare it both within the United States and internationally, and I think the record is compelling in favor of a criminal justice approach.
Thanks. I'd like to shift, in the interest of time here, to neck down this question to due process questions and treatment questions, which are both very much before us and have not really been resolved yet by the current law, either from the habeas litigation or from what's been produced as a matter of policy or through executive order. Eric wrote with a colleague an article that hasn't been published yet, has it, Eric? No. But it gets to this issue of if we choose law of war-based detention, then what due process should be involved? How should the review be conducted? What should be periodic as the Geneva Conventions require? Who should be involved in that review? But also what treatment standards should be applied to those individuals who are detained under a law of war basis. Eric, would you address that side of the issue?
Sure. So my colleague who worked on this with me, Chris Jenks, is currently in the Democratic Republic of Congo and can't be here. And he is probably the genesis of most of the smart things I will say. So I do need to give him credit if I say anything smart. Starting with the treatment standards, I think Mr. Jackson introduced at the very first of this the two task forces, one of which looked at the treatment standards and then kind of gave a review, issued a report on what those standards were like. And we considered that as we wrote this article. And the report says that in accordance with Common Article 3, the treatment going on at Guantanamo is fine, adequate, sufficient. And we reviewed that kind of on a more expansive scale of what, if you didn't just rely on Common Article 3, but instead you conflated low-act protections, how would that play out? And we agree that still the treatment going on at Guantanamo now is quite favorable to that. Now, we did find certain things that we thought are not being done in accordance with the law of war that could be done. And then we also came up with some suggestions as to things that we thought could be done to maybe, I don't want to say humanize, because I actually am a fan of the law of war, but would maybe make it seem more humanistic to us as we reviewed it. Let me just throw out one example. For example, the law of armed conflict model allows for telegraphs, communication with your family if you're a detainee under a law of war paradigm. I mean, that's crazy, right? Now we think that ought to be modernized. We think that there are ways that we could do that. So let me just very briefly talk about some of the things that we think ought to be done now, and then I will go back to the standards that I think that we're doing, that we could do better. So some of the things that I think ought to be done now that are not being done now, and there's really only a couple, but one is the establishment of an information bureau. If you read the law of armed conflict model for detention, whether of civilians or prisoners of war, this idea of keeping information and making it available to people who are interested parties is clear. And I don't think the government has done a very good job of that. You can find information and you can search, you have to search a lot of different sources, but I think we ought to be able to compile that and give that to everybody. I think the idea from one place. Again, security concerns of all of these things, I will make adequate allowance for security concerns and say we have to consider that. There's some information you don't want to give out. There'll be some people who are currently detained who don't want their information out. We'll have to respect that. But generally, we ought to have a place. The law of war talks about a protecting power and talks in great detail about the services that a protecting power could serve. And the United States has not taken advantage of that law of war principle and should, for a number of reasons, not only for the protections that it provides to detainees, people who are detained indefinitely, but also for the clarity and the statement of the things that the detaining power is doing well. I mean, it would be nice to have a third party who was respected, who was not only concerned about taking care of detainees' rights, but also concerned about demonstrating what the detaining power is doing right, so that we get a more clear third-party picture. Right? We think that would be helpful. And that, of course, actually has nothing to do with indefinite detainees. That should be happening with all detainees. The idea of a detainee committee, elected representatives, I mean, again, that is all throughout the law of armed conflict, not currently in use, at least as best we can tell, and should be. We think that that would allow these detainees to have a voice, which goes to the fourth point of what should be done now, which is the formalization of complaint procedures. There's no evidence, and again, I will be the first to admit I don't have access to everything that's going on. I'm only looking at open source stuff like you are. But there doesn't appear to be any evidence that there's a formal complaint procedure where detainees can file complaints and talk about their needs that aren't being met. That should be done, and if they had detainee representatives or a committee, that would be a method by which that could happen. Now, another thing is once this decision to indefinitely detain is made, there ought to be a notification not only to the detainee but to other interested parties, including the protected party and, of course, including the detainee's family. He ought to be allowed to notify his family and say, I'm not coming home, whatever. And then relocation, they ought to be separated from other detainees who are either waiting for repatriation, transfer, whatever. If they're indefinitely detained, they ought to be separated and put on their own. So now, very briefly again, the treatment standards that should happen with indefinite detention. And let me just caveat this by saying that Chris and I took as a given the fact that this indefinite detention decision had been made. And we don't address, and I will not address here unless you want me to, what I think about that issue of indefinite detention. But what we really focused on was, let's assume the decision to indefinitely detain has been made. How can we make this as good as possible? So there's a long list in our paper of things we can do, and let me just highlight a few of them. One of them would be communications with the outside world. Right now, that kind of communication is limited. We think with full accounting for security issues, that if someone's given a term of indefinite detention, they ought to have the opportunity to have, for example, internet access, censored as allowed by the law of armed conflict, but they ought to have internet access where they can have an email, right, where they can actually communicate with their family, they can communicate with appropriate outside sources. Again, we're not going to let them communicate with other people to, plan the jailbreak or to foment more terrorist activities. That's not what I'm talking about. That's not what the law of war would allow, but they would certainly allow other kinds of communications. There's a great deal going on in Guantanamo about education services and things like that, but there's no evidence at least that the detainees have much input in that. Why shouldn't they? They ought to have input in their own educational regimes. They ought to be able to pick what they want to learn about. Again, subject to security concerns, things like that. They ought to have family contact. They ought to have contact with outside sources. They ought to be able to have religious services brought in from the outside, all subject to security concerns. They ought to be given this is kind of one of those things that I think many people think is quaint about the law of war, but they ought to be given an opportunity to have a canteen, meaning they can order in specific goods that they want that the current camp is not providing, and that the proceeds from that canteen ought to work to their benefit. I mean, they're just things that help morale. None of you have been indefinitely detained, obviously, because you're here. I think if you think about things, it would make you, if you're going to be indefinitely detained, what's going to make your life a little easier? Contact with the outside, a bit of freedom, to be able to get some of the things that you like. One of the key things we think is they ought to be given permanent quarters. One of the methods of disciplinary action right now at Guantanamo includes moving them from a set of quarters to a different set of quarters under a different disciplinary standard. There is no set place that detainee calls his place, his home of indefinite detention. If he's going to be there indefinitely, he ought to have a place. And if he's moved temporarily for discipline, he ought to be able to go back to that place. And at that place, he ought to be able to have pictures of his family. He ought to be able to have personal items. He ought to be able to make that place as much a home as he can if it's going to be indefinite detention. And then review of detention. And this is really kind of a murky area. As Mr. Jackson was mentioning, the law of war has some pretty clear standards for review of detention. And the most important for this issue, I think, are that the review is semi-annual. At the time the detainee is given opportunity to have an attorney, to call witnesses, to present evidence, and most importantly, the presumption is when the administrative board meets to review his detention, they meet with the presumption that he will be released. In other words, they have to find, as a board, that there is still a reason to continue indefinite detention. And I don't know that that's the standard now. I don't think that's the standard now. I think that if we accept the law of war paradigm for indefinite detention as the President has seemed to have done, then the presumption would be that at these semi-annual reviews, after they presented their evidence and been able to advocate on their behalf, the presumption is that they're released unless there's sufficient evidence to determine there's still a security risk. There's a reason that they should be detained.
Eric, there's really a paucity of guidance within the law of war itself about the due process that is involved in the review of detention, beyond the periodic review requirement and the requirement for an administrative tribunal at a minimum. Is there another source of law you would recommend to seek that from those procedures from? Would you recommend melding any other sources into this?
So
approach?
we relied pretty heavily on Army Regulation 190-8 to look, and also then military administrative proceedings, because there's already lots of process there. These are governed by rules that are based on military principles, military procedures. So we relied heavily on them to fill some of those gaps that we think, again, give some robustness to fill up the gaps that are not obvious in the law of war.
Thanks. Lori, in your study of the law of war, do you see any benefit to adopting these due process standards from the law of war, or are you essentially with Joan that the law of war detention regime is not appropriate for this group of individuals?
Thank you. First, let me just thank you for inviting me. Is this on? Inviting me to be here. I rarely need a microphone, so. In answer to your question, I would say that two things. First of all, obviously, the more robust the protections, the more robust the process, the better, for sure. And I think Eric and Chris's article gives a great example of how to really flesh that out. But to go back to some things that were said earlier, I don't think we should be prepared to simply accept that, well, we are detaining people, so let's just go to the next step and talk about how to do it. I don't think we have to accept something just because it's already being done. That said, I don't think we should just say no and not think about the consequences and the issues. So what I want to do is, sort of taking a little bit of a broad stroke view, highlight three problems. And one is a problem of definition, one is a problem of purpose, and one is problems of perspective. And with this, in highlighting these, I would say that there is a role for law of war detention in general in what we're talking about. I don't think what is being called law of war detention today for these persons identified at Guantanamo is necessarily that law of war detention. So I think we have a stretching and perhaps a perversion of the term. That said, I wouldn't say we need to get rid of it altogether. So in terms of the problem of definition, the first one that I mentioned has to do with some questions that we have not yet been able to define that really pose some, hopefully not intractable, but clearly challenging questions. One is battlefield geography, and one is the time frame of the conflict. So law of war detention, we often hear it called battlefield detention. That's because traditionally it's people picked up on the battlefield. You know, you can all remember All Quiet on the Western Front, the guys on the other side, the other trenches. But we don't know where exactly the battlefield is. We know it's Afghanistan, sure, the border areas of Pakistan, certainly Iraq when we're fighting there. But if we are in some kind of conflict with Al-Qaeda and associated forces, where is it? And I guess that leads me to a similar statement that the royal we, sort of American society, has been very accepting of the notion that we are in an armed conflict with terrorists, or the war on terror. Certainly there's been a lot of discussion about that, but by the same token, again, that doesn't have to be taken as sort of a lump sum statement. There can be qualifications to it. So questions of defining the battlefield, in essence, are really critical to these discussions of detention, just like they are to targeting. In the same sense, it has to do with where we can engage in a law of war authority. And so, just very quickly, you know, we look at traditional frameworks. The law of neutrality used to help define where the battlefield was. That doesn't really work in counterterrorism. That doesn't work very well in the type of conflict we're engaged in. We don't have terrorist groups who have territory. We don't have analogous situations. And what's really interesting, actually, just as a little piece of this, is that we see very clearly that the U.S. federal courts, predominantly the D.C. District Court and Circuit Court, but also some other courts that have dealt with some of these cases, they clearly see the United States territory as outside what they've referred to as the zone of combat or active zone of hostilities or the battlefield or whatever term you want to use. And if you look back to World War I and World War II, it was exactly the opposite. We have cases where the courts refer to the Port of New York as within the zone of active military operations, or other parts of the U.S. were clearly viewed as belligerent territory. So this is an interesting statement that we have a courts, which are, as you've mentioned, the main actor in sort of the definitional process that's going on here, who both see us as engaged in some type of worldwide or global or at least non-territorially defined conflict, and yet where we are the main party in many ways, the other side being hard to define, and yet our territory is not in the bounds of that battlefield. So that's an interesting, that sort of highlights the definitional challenges here, just in terms of understanding when we find somebody, are they someone engaged in this conflict? Are they on the battlefield? Are they near it? In some way affiliated that makes sense for us to think of them as part of this, or, are they not? And we can see this in practice, how we view differently people who are in Yemen, people who are in Paris or Hamburg. The U.S. inherently takes a different approach to those people for a variety of practical and policy reasons, but it still highlights some of these issues. The question of timing is almost even more complicated. What do we see from the law of war?
Lori, first, let me interrupt. How would you define that geographic area if you had to define it?
You got two.
Two. Anyone who knows me would say you don't even need one. But, are you trying to get me to talk about my... I think the question of the battlefield does need to be, if not defined as in actual geographic parameters, we need to have a better sense of how to assess it. And I've written on this an article, and I think it's useful to look to the law of war to find an understanding of how we can define the battlefield. Because, like I said, the law of neutrality is our traditional way of finding the battle space out there. It's anywhere that's not neutral territory. But we don't have neutral territory in a fight with terrorist groups. So I think we can look to some factors that are used in the law of armed conflict in order to try to figure out where this battlefield is. Things like, what are hostilities and where are they taking place? When do acts that terrorist groups engage in, when are they akin to hostilities that we think of in terms of more traditional military combat? What about the government response? That's another factor that's taken into account in trying to assess whether there is an armed conflict at all. If you look at a common Article III jurisprudence like the Tadic case and other cases before the ICTY, they'll look, in addition to hostilities, whether hostilities are taking place, they look at the government response. Is the government responding with military force? Is it responding with a law enforcement response? That's one that you have to be very careful with, because it puts maybe too much weight in the government's hands, because they could simply respond with military everywhere and say, look, everywhere's the battlefield.
How about the approach that Dean Coe announced at the last ASIL meeting with regard to ungoverned spaces or areas where a state is unwilling or unable to act? Would you include those geographically as part of an area where law of war detention might be appropriate?
Well, I think a lot of those will inherently or certainly fall into an area that could be part of a law of war defined battlefield, but I don't think necessarily because of those characteristics. In other words, I don't think that I would say ungoverned space is inherently, because it's ungoverned, part of the battlefield. But it brings me to the last kind of factor or issue that I would want to look at, which requires the most creativity, I think, which is territory. When we look at a classic NIAC analysis of whether or not there's a NIAC, a court will often look at whether or not the non-state party, the non-state actor, controls territory, whether they're using territory in order to launch their operations. If you think of a classic rebel group versus a government, not in a terrorism context, are they trying to govern territory, things like that? Obviously, it's not required for Common Article 3, like it is for additional protocol 2, but it is nonetheless something courts will look to. It's part of the analysis. How does that work with a conflict with terrorists? Well, they are usually not looking to control territory, but what about how they use it? And that's where the creativity kind of comes in, which is where do they have their safe havens? Where do terrorist groups engage in their training camps? Where do they launch their attacks? Where do they focus their attacks? And so is there a footprint? Rather than territorial control, I would look at it as a footprint question. Ungoverned spaces are naturally a favorite location to have a footprint. If you are Al-Qaeda or another similar group, they're not going to go to places and seek safe haven in, highly regulated areas because that's not friendly to them. So, as I said, I think those will naturally fit within this type of area, but not necessarily solely because they're ungoverned. And what I think, for me, this helps try to figure out where between a global battlefield, which I find problematic from looking at things from the protective viewpoint of LOAC, which is that we have a lot of civilians who this law is designed to protect. It has a lot of other purposes, but one key purpose is protection of civilians. If you make the whole world a battlefield, you have a whole lot of civilians who are now in danger. And so that's problematic. If you limit the battlefield very strictly to places of active military combat like Afghanistan, you have other, I think that's too narrow, because there are things that are very similar to hostilities going on, and there are areas where we are engaged in activities very similar to combat, very closely related to it, and so there has to be some middle ground. And again, this impacts detention just as much as it impacts targeting, because uncertainty is problematic. As you said, if you pick someone up, you have to know what to do with them. You have to figure out who they are, why you have them, and why they're where they are, and what you're going to do with them. We all, I think, can understand why the question of timing is so difficult, but yet poses such a challenging question of definition. And, when are the general close of military operations? When are the end of hostilities? I don't know. Maybe some of you can help me figure it out. But I think in that sense, I would just highlight one point, which is that in traditional law of war detention, when POWs are detained, etc., yes, they are held for an unknown period of time. You don't know in 1941 that 1945 is going to be the end of World War II. But it's not an undefined period of time. And I think that's a difference here, which is that we have a problem of it's undefined. We don't understand what the end is, not just that we don't know when it is. Just quickly on the other 2 points, the problem of purpose here is that we have something that is generally, historically defined as protective custody, and it's now morphed into punitive custody. And I think I would dispute, Ben, your point that we are engaged in non-criminal detention, because I think in many ways we are engaged very much in a form of punitive and closely akin to criminal detention. There are cases where we could be engaged in a protective custody, but one way that I like to look at this is that we often see people talk about, well, we have some different tools available to us. We have Article 3 courts, military commissions, or detention. But they're not on the same level. We have prosecution and we have detention. And to suggest that a form of detention is an alternative is akin to prosecution, that leads, at least for me, that leaves me with the gut feeling that this is a punitive form of detention. And that's problematic when there's no charge involved and a totally different standard of process. And finally, the problem of perspective is one that obviously is unfortunate. It's the nature of the fact that we're 10 years after 9/11, but a lot of this is being done as a reactive posture and not as let's imagine we're back on September 10th in 2001 and someone said to you, okay, we are soon going to be involved in an undefined conflict with an undefined enemy in an undefined area. We're probably going to pick up a lot of people, and we're going to want to question them, and some of them are going to be pretty scary people. What framework? How do you want to design this? Instead, we have a situation where we're told, these are guys we don't want to let go for a variety of reasons. And in many cases, it's our dirty hands, why we don't want to let them go. Not all. To prettify that, I think, is sort of like putting icing on a burned cake in many ways. And that I have a problem with coming up with a system solely because you have a result that you want to make a little bit prettier. And I think in some cases, it's ultimately what's needed here is a much more robust discussion with the American people about what it means to be engaged in counterterrorism over the long term. We have national security, which is our magic bullet for the last 10 years. Nobody's been able to argue with those two words. But we also have a lot of core American values. We have individual rights and protections. And that conversation has not been had with the American people about how we balance those. And we may not come to the result that we have today. We might. But I think we need to have that conversation.
Well, I hope we're starting that conversation here. But,
I hope so.
But Lori, two of your last 3 points, the timing point and the point about punitive detention, kind of merge at some point.
Mm-hmm.
And it may be suggested by the Hamdi reference from Justice O'Connor about when law of war detention ends and something else begins. I gave the site of the 20-year detention of the Moroccan pilots. What would you say is an endpoint? And how would you, if you were drafting legislation as to define what law of war detention means, where would you say one ends and the other begins? And how would you make that determination?
Well, I think my answer would be that I would, and I know this is going to sound a little bit like I'm punting, but I would say that when you have a problem that you cannot effectively define the timing, you cannot then have a detention system that uses timing as its endpoint. So until somebody can explain to me when the end of hostilities with terrorism comes, because I'm pretty sure it will be not when I'm still here able to talk coherently about this stuff, I think that instead the system should be designed to reflect that. And so we can't have a system where we say we're going to hold you until the end of some hostilities with your buddies. And we don't even know who all of your buddies are. Instead, we have to define this. This, therefore, takes what is law of war detention and turns it, essentially, it turns it on its head. Because if we can't define the end game, we can't have a system that ends with an end game, because now you have none. So instead, I think you have to have a system where instead of having it's indefinite and if it either it ends or ultimately you're no longer dangerous. And the nature of counterterrorism is that there are so many links and morphing and this and that you'll probably be dangerous until it ends. You can see where I'm going with this. You're going to be here for a while. I think we have to have a system where we define a person's detention timing based on other. It can't be based on the end of some hostilities with, or the end of terrorism or terrorism hostilities or terrorist acts, because it's inherently, it's like void for vagueness. I mean, it's inherently unfair.
So are you suggesting that it should be based on an individual determination of dangerousness? Or what should be the standard for determining that the detention ends?
Well, I think that if a person is linked to an actual armed conflict, not a terrorism situation, like somebody from the Taliban or something, or in Iraq or something like that, then you have parameters. And if it turns out that conflict has morphed into counterterrorism, you have a problem. But yes, I think it needs to be based much more on individual conduct. It has to be much more based on a criminal justice model, where seems to me that if you are so far removed from a law of war model because of this timing question and you don't know and linkage of groups and things like that, then you're really much more in the criminal model. And we have ways in the criminal model, we have crimes like conspiracy and attempt and all these other things where we have ways to address questions of even future dangerousness. And if somebody is actually that dangerous and we have that information, then in a lot of cases I think we ought to be able to prosecute them and give them trial and accountability and find some way to have resolution. Because really, I don't think the U.S. ultimately wants to be in the business of holding people for all time. I'm sure that if we could get out of this detention business, it's not exactly a favored activity of our government either, and nobody really likes this process. So I think I would say we have to try to understand, not conflate criminal and law of war so much, and try to disaggregate them.
I just want to give one chance to Ben to address the timing issue, because it's one you weren't able to address earlier.
So I think for a lot of the reasons that Lori described, the effort to define the battlefield is almost invariably fails, because I think the issue is so multifaceted and so diffuse, and any line that you draw will be tested tomorrow and will fail the next day. The issue of the termination of hostilities, however, I think is a very profound one that does not give rise to necessary failure, and I think gives you a lot of guidance in designing a detention system of how you want to think about an individual. So let me, having said that, let me zoom out a little bit, and then I'll zoom back in. So there is a myth, it's quite pervasive myth, that when we say indefinite detention, people think of this as endless detention. And they use the word indefinite to refer to detention without end until you die. And they contrast this with the criminal justice system, where you're sentenced to a period of incarceration and then you're let go. Now, that may be a long time, but at least you get let go, right? Now, the reality is actually quite different from that, which is that so if you imagine the 800 people who've passed through Guantanamo, more than 600 of them are no longer there. A very great number of them were let go rather quickly. Some of them, had they been charged, they would have been sentenced to extraordinarily long terms in prison. Well, let me give you just one example of this. When Yasser Hamdi, to whose case we've referred earlier, was very similar, the case to whom he was most similar that ended up in the criminal justice system was John Walker Lindh. John Walker Lindh is they're both American-born people who found their way to the Taliban and ended up getting captured. So they're both US citizens who end up with the Taliban, and we catch them. One ends up in the criminal justice system, and people like me, when I was an editorial writer, were writing editorials saying, this is the way you're supposed to handle this, this is the model of the way you're supposed to handle it, just charge him. And one of them, it produced enormous anxiety in people like me. This was Hamdi, who was being held in indefinite detention and was a great civil liberties problem. Now, Hamdi was out in 3 years. And John Walker Lindh, the last I heard of him, had petitioned for executive clemency on the basis that the 17 additional years he would serve after Hamdi's release was arbitrary and capricious with respect to him. So the idea that the criminal justice system produces sort of justice for detainees relative to indefinite detention is actually quite mythological. The reality is that indefinite, we should think about it in its dictionary sense, which is without definite ending, indeterminate. And oftentimes, the vast majority of the time, this will work to the benefit of the detainee relative to that person who ends up in the criminal justice system. The criminal justice system is mighty freaking harsh. It's really, really harsh. When you get convicted in the criminal justice system for a counterterrorism offense, you go away for a long, long time. When you end up in indefinite detention, 600 plus of the people who are at Guantanamo are out by now. So keep that in mind as your background. Now let me zoom in on this question of the end of hostilities. When you detain somebody, I agree with Lori almost completely. When you detain somebody and you look at that person and say, at the end of hostilities, however we can imagine it, I'm not letting this person go. KSM is detained as a law of war detainee right now. If you ever let him go, the hostilities will start again. He's not, some soldier, right? He's the organizational leader of a movement that wants to do things, right? So you can pretend at some mythological level, that you're holding him until the end of hostilities. But his freedom actually defines the state of hostilities. And so when you look at a detainee and you know that that's who you're dealing with, I think the laws of war have a relatively limited application as the basis of that person's detention. You can cram it in there if you insist on it. Where I part company from I think Laurie and Joanne would probably agree with me so far. Where we part company is on the second question, which is, therefore, is there no other basis for non-criminal detention? And when I say, just for clarification, when I say non-criminal, I don't necessarily mean it doesn't have punitive effect. I mean not pursuant to criminal law. Now, I think the answer to that question is, we have a lot of areas in our non-criminal law where we authorize long-term detentions. One of them is mental illness, where and pedophiles, whom we lock up after they've completed their sentences, often for the rest of their lives, on the basis that they pose a danger to other people. You can imagine bases other than the criminal law and other than the laws of war that would entitle you to lock up somebody for a very long period of time who poses a monumental danger to society. My point is, but I agree with them that if you're looking at somebody and you can't imagine that you could have an end of hostilities with that person free, you probably should be thinking about something other than law of war-based detention. I look at that and I say, you need some kind of a hybrid model that gives them a lot of the process associated with the criminal law and a lot of the detention power associated with long-term detention. But I don't conclude from it that the only model that can give you that is the criminal model. But I do agree that this is profoundly challenging to law of war detention, and that it helps guide the parameters of where you should be using law of war detention.
Well, I think we ought to get to your questions. I'm not sure we hit the mark of describing what law of war detention ought to look like, but really our intent was to get a dialogue going. So can we get to your question, sir? Yeah. Thanks, Veronica.
Anthony Dworkin with the European Council on Foreign Relations. And I want to talk a little bit to this question about the parameters of law of war detention and how it applies in non-international armed conflict. And basically what I want to suggest or put to the panel is that law of war detention is not relevant in non-international armed conflict. I think it's just been accepted much too easily by the kind of both opponents and supporters of what the administration is doing, that if you have an armed conflict of any description, that therefore there is a kind of authority to detain enemy fighters until the end of hostilities, carried over by analogy with an international armed conflict. And I think there's a very big difference between this situation and the situation of an international armed conflict, which is based on the point that Ben Wittes mentioned. Law of war detention is by definition status-based detention. And the idea is that the legal relationship between the two parties to the conflict changes at the moment of entering an armed conflict. That gives rise to some sort of notional authority to detain members of the enemy force until the end of hostilities, or to target them as long as they're not hors de combat. I think the whole model of status-based detention is not relevant in a non-international armed conflict because there is no legal relationship between the parties to the conflict. I mean, Al-Qaeda is not an entity that has any kind of legal relationship to the US that changes at the moment of entering an armed conflict. And that's made perfectly clear by Common Article 3, which says, quite specifically that the legal relationship between the parties doesn't change. So I think it's always individual-based detention. It's always threat-based detention in a non-international armed conflict. And I think, maybe if you look at it that way, then some of these kind of very tricky definitional questions about the parameters of the conflict, the territorial boundaries, the temporal boundaries, and so on, can seem a bit less relevant. And what you need is some constructive thinking about what are the individual circumstances that give rise to detention, probably by reference to sort of human rights standards. And I think some of what Ben Wittes is saying goes to this point about threat-based detention. But I think that the missing element is some sort of notion of what's the background situation that would give rise to this exceptional power to detain people, because otherwise the damage that it could do to any notion of the international rule of law is, quite extraordinary. So I think you'd have to formulate some kind of, international state of emergency, very tightly bound, and, beyond that, certain geographical circumstances and so on. But the
Did
idea
you want to
that,
pose a question to one of the panelists? Or
well,
in particular?
I want to know what they think about that. Where is the detention authority in the law of war for these kinds of conflicts?
Joanne, do you agree with his point?
I would agree. I don't think it's makes a huge difference, but international law perhaps doesn't extend the power to detain. It delegates it to a state's domestic law. And I don't think it's too much of a stretch, particularly given U.S. history, to say that the AUMC provides that power to detain when the U.S. is in an armed conflict, as it is in Afghanistan, that the U.S. has the power to hold people that it picks up in Afghanistan. And I think, I agreed, as you kind of suppose, with much of what you said in terms of distinguishing, this difficulty of distinguishing the temporal end to the conflict and the distinction between outside circumstances that make the person dangerous. So you hold the combatant because in a wartime situation, that person, if you release them, is going to go back to the fight. The distinction between that person and a terrorist, whom you hold because that person is personally dangerous. As you were saying with Khalid Sheikh Mohammed, if he were to be released, the threat would be present again. And I think in a non-international armed conflict, it's much less the personal dangerousness, although that's an element more than in an international armed conflict, but it's largely the context in which you would be releasing the person into. So, in that sense, I would say that, whether it's international law, some argue that it's customary international law that provides the power to detain, or whether it's a state's domestic law, is not really a crucial difference. I think the crucial difference is between the sort of terrorist criminal situation and the armed conflict situation.
We've all kind of danced around the choice of law question that's involved here. And so what we're doing to some extent is conflating international armed conflict-based law of armed conflict into non-international armed conflict. And in non-international armed conflict, there's some conflict with human rights law, but the U.S. position on human rights law is it doesn't apply extraterritorially. So, so we have essentially a void of law, maybe, with respect to individuals that are detained outside the U.S. Eric, in your analysis of this problem, did you feel uncomfortable with applying IAC standards to people that, under Hamden at least, are to be are detained under a NIAC basis?
Yes. I felt a little uncomfortable just because we were conflating separate theories of law. But I am not, I'm a little troubled by the idea that we are so territorially and geographically bound. Even the law of war talks about a fight between two state parties, but it doesn't contemplate that fight only happens within their geographical boundaries. Members of those armed forces would be at war wherever they contacted each other, and there's tons of historical examples to support that. Now, the leap then you have to make is that a fight with Al-Qaeda can then somehow draw in those IAC principles. And I'm a little uncomfortable just because if I'm a positivist, I want to say, well, that may not, it doesn't seem to fit very well. But I think the reality of it is, and certainly state practice is leaning towards the fact that's not too problematic. And that instead you would look at detention, the standard is not until the conflict ends. The standard is, as you said, until the conflict ends or the person becomes undangerous. And if you set up a review process with sufficient protections, then at the point that person is no longer dangerous, then it doesn't matter if the conflict is ended, he or she can be released. And so the idea is to set up a methodology for determining dangerousness, and you can bring in great law of war principles such as parole, that is now more abundant in the United States, but could be highly activated very effectively with new electronic monitoring measures. You bring in release, repatriation, transfer, all these things that, though they're IAC principles, they fit very nicely in the current situation that we're in, and I think provide us with an opportunity to make the situation better than it might be.
And you also addressed in your article rehabilitation as a potential means to the end of lessening the dangerousness of the individual. And rehabilitation has been introduced both in Iraq and in Afghanistan under Task Force 435 as part of the law of war-based detention model. Do we have some other questions out there?
Hi, I'm Cole Cartledge. I wanted, I guess, direct this to Lori and to anybody else who'd like to talk about it. I'll try not to ramble too much with it. I'm Cole Cartledge. I'm a retired Army officer. Have worked in international law in Bosnia, and also I was in Iraq 3 years ago. I have huge issues, and I will say that I'm in the minority with my comrades, but I have huge issues with Guantanamo, with the torture that's gone on there, and other things. But getting back to your point earlier about, and several people's point about the definition of terror, and that, in my own personal opinion, is that terror really is it's a criminal act. We should deal with it as such, and you get it out of the law of war issue, because it's just too hard to define it. So there's a myopic sort of way that we have from the United States to approach, like, we're the only ones who define this. I worry, 3 years ago when I was on the Syrian border, when I was working in civilian clothes in Iraq, I could have easily been captured. We have people that wander over those borders all the time, and if they're captured, the thing I wonder about, and my question really is, why we don't talk more about this is why don't we look at the other side of it? If our service people are taken, and my friends who don't think there's anything wrong with waterboarding or sleep deprivation for weeks at a time, or having people, in cold environments for long periods of time. I'm like, okay, if I had been captured by the Syrians, by the Iranians, by an al-Qaeda group that was in Pakistan, would you think it was okay that they did these things to me? Is that okay? Is that the standard now that we're going to have internationally? Can they waterboard me? Can they do all of these other things? And that's my concern. I wonder why we don't talk about that more internationally, and throw that back in the administration and the people that are doing this and saying, would this be okay for our soldiers? Would it be okay for our people that are over there? Is that the standard now internationally?
Well, that's not the standard nationally. And this issue was resolved back in 2005 when the Field Manual 2-22.3 for Human Intelligence Operations was issued, and the Detainee Treatment Act said that that was the standard. Now, the standard is exactly the one that you allude to, which is reciprocity, that is the basis for the Geneva Convention for Prisoners of War. And the standard follows for interrogation under the Army Field Manual standard requires that you be treated as if you were a prisoner of war, and bans all of the techniques that you're talking about. And in fact, the Obama administration's executive order on the second day of his presidency also banned those techniques. But Lori, did you have a comment?
Got my double-fisted here again. I think I agree completely with you, and not solely on the treatment questions, but I think your point is very relevant also from the paradigm or parameter questions. If we think about what we might have thought of as a NIAC or a sort of traditional NIAC, you have a rebel group fighting against a government, et cetera, you could have situations in which the government forces are detained by the rebel group. And in that sense, we may not find numerous provisions in the Geneva Conventions that outline detention in a NIAC, but certainly the military necessity creates the authority for detention. We wouldn't want a regime where you if you're in a NIAC, well, if you see a bad guy, you kill him because you're not allowed to detain him. That doesn't necessarily make a whole lot of sense. So I think your question is relevant not just to treatment, but also to the broader paradigm of what type of detention, what type of how do we want the other side to view our forces in this sort of amorphous situation that we're in? Do we want there to be an understanding that there is a regime for detention that is governed by international standards in a NIAC or some other undefined type of conflict or conflict similar situation? I think the answer would be yes, based on our historical understanding of the role of reciprocity. I mean, look at what we did in Vietnam. I mean, a lot of the genesis for the screening procedures and the status procedures in Vietnam were based on the need to get protection from American pilots who were being shot down. We had an incredibly wide-ranging set of parameters for who was detained and who was held as a POW in Vietnam, much wider than we have now, and that was really a protective purpose for our own troops. So I think your point is very well taken in that respect.
I also thought when Eric was talking that the protective principle comes to mind, that in the Geneva Conventions are intended to protect a class of individuals who are out of combat. And that protective principle is also incorporated in Common Article 3 that talks about those that are hors de combat. So in the conflation of IAC standards and principles and treatment, which is what we're talking about here, into non-international armed conflict is a trend across the board. It's been the U.S. policy for about 30 years to 40 years. 1974 was when the policy was first issued that the U.S. forces would apply international armed conflict, law of armed conflict standards on whatever battlefield we're on. Now that has another benefit. The benefit is that the soldiers are trained to a standard that they can apply anywhere. They don't have to ask, am I in a NIAC, am I in an IAC? They don't have to go through this existential question. They know that the standard is the standard prescribed by the Prisoner of War Convention or the Civilians Convention. Some other questions out there? You back there, sir?
Hi, I'm Martin Hindle, and I work in the Office of Military Commissions. And I've heard Mr. Wittes speak twice now, and my comments will be directed to you, sir. But anybody can answer if this culminates in a question, and I'll try to be brief. I have to tell you, Mr. Wittes, I've heard you speak twice, and both times your comments have left my stomach in a knot, and I've been trying to figure out why, and I think I know why. Your introductory comment, if I understood it correctly, was that we really should concern ourselves with the question of whether there should be indefinite law of war detention because all branches of government have already settled the question. And until the late 1950s, all branches of government and several administrations agreed that separate but equal was legal. But people didn't give up there, and I think we're fortunate that they didn't. I want to just set a few parameters because I've worked in this field for 2.5 years. I've gone to Gitmo dozens of times. Guantanamo is currently populated by approximately 172 men. As Mr. Wittes stated, there were, I believe, 800 total throughout the time they've had it open. Almost 90% of them have never been charged with anything. I think it's about 86%. Never charged with any offense. There's one person down there by the name of KSM, and over 25% of those people down there have been determined by the government that has detained them to no longer be a threat, or actually to never have been a threat, and to be candidates for repatriation to their country, or if that's not possible, to be sent to third-party countries or to the United States. But for various reasons, which I believe are political reasons, none of those people, or a very, very small number of them, have been sent. I'm saying this just to succinctly point out that there's a tendency to portray everybody down there as the worst of the worst, when in fact there are many, many people there who may never have committed any kind of an offense and may never be charged with any offense. And what we're contemplating here in our country is detaining those, or giving the government the authority to detain those people indefinitely. And Mr. Wittes, you could disagree about the definition of that, but to my mind, indefinite, as the president is contemplating issuing an executive order on, what that says to me is the administration that has locked them up is going to have the sole decision-making authority on whether or not to detain them indefinitely, which means as long as they decide that those individuals remain a threat, with no judicial review. And this is what we're signing up to. And I would like to just take very, very strong issue with the proposition that because all branches of government have settled the question, we need not concern ourselves with it. In my opinion, it's a live legal issue. As far as I know, the Supreme Court has never decided that at Guantanamo, the men there, 10 years after their capture and thousands of miles away from the active theater of battle, that it's legal to detain them indefinitely. The Supreme Court has never determined that. To leave alone the moral issues, the huge moral issues that are raised by this. And I think it's frankly irresponsible for us to agree that we need not concern ourselves with this because it's already been decided. Thank you for listening.
I'm sorry, your stomach is nuts. So let me address. Time will not allow me to address all of your points, but let me address several of them. First of all, I take a little bit of exception at the comparison of the point that I made to a defense of segregation. When I say that the question of the fact of detention is a resolved question, I mean something very simple and frankly empirically true, which is that there was a time after 9/11 when what was actively being litigated was the question of really whether you could do this at all. And what is being litigated now is a different question. And I spend probably about a third of my time, 25% of my time, following every single one of these pieces of Gitmo litigation. And I have a very granular sense of what's being litigated. And what's being litigated right now is not the reality, the underlying question of whether we're going to have a detention system. It's the details of that detention system. And it's the question of who's going to build that detention system and whether we're going to take responsibility as a society for having a real discussion about the circumstances in which we want to engage in detention for all the moral reasons that you raise, or whether we're going to let A. Raymond Randolph, Merrick Garland, Stephen Williams, and some other people whose names a lot of people in this room have probably never heard make up the rules for us. I don't think that that is a question that is, I think the irresponsibility of a societal decision to punt that question to a group of nameless judges is almost unspeakable. I think the irresponsibility of the Supreme Court of the United States in Boumediene to say, yes, there's habeas at Guantanamo, but we're not going to tell you what it means. Now we're going to let the district court, in the first instance, figure it out, is approximately as irresponsible as it would be to say, you know what, for the Supreme Court to say 5 votes, yeah, there's a criminal justice system, now go figure out what that looks like. And so you can say that I'm sitting here defending segregation, and but I am observing, but I say something else, which is that I'm observing that we have not had the stomach as a society to tell the executive branch or the Congress of the United States, no, we are under no circumstances going to detain somebody outside the criminal justice system. And if you want to keep fighting that fight till the end of time, be my guest. But I have a different question, which is if we don't have the stomach to do that, to say that, we certainly should have the stomach to define the rules. And that's all I'm saying. And I don't make any apology for it. And I don't make any apology either for the belief that sometimes non-criminal detention is absolutely necessary and reasonable. I do think it has very substantial moral concerns. I want to debate those. And I don't want to debate those to avoid debating them by pretending that we're really discussing whether we're ever going to do it at all.
Well, and just from a perspective of an observer, there's an executive order coming out very soon that deals with this very question, and so maybe we ought to have a dialogue both about whether or not we should, but how we should, and that's really the intent of this this panel today. Ma'am, you had a question. I'm sorry I didn't get to you sooner.
Hi, my name is Lee Tucker, and I'm with the Public International Law and Policy Group. My question is for Eric and Ben together. Eric, you had mentioned the review process and how the law of war gives us some guidelines that the presumption should be that people will go in and be released unless there's a finding that they are still a threat. And I'm just wondering what that kind of review process might look like. How could it be possible that somebody has been such an extreme threat and then they would go into a review process and either disprove that they are still a threat, or there would be a new finding that they are still a threat?
So let me see if I can quickly find the language. Here it is. So it says, this is from the Geneva Conventions. It says, continued detention could result in, indeed indefinitely so, but the presumption is a view to favorably amending the decision to detain. So that the quoted language is a view to favorably amending the conditions of detention or the detention at all. So how would that happen? I mean, I think in this hearing, the government would obviously be able to put on their evidence, and those who were sitting in, I don't want to say judgment, those who were reviewing the case would then listen to the government's evidence and assume that, unless the government proved otherwise, that they would favorably amend the conditions of detention or even the fact of detention of that individual who was detained.
Just a sec. Would you add administrative board proceedings with any form of review and/or representation by counsel to this panel?
Yeah. So the assumption would be that when that detainee came before the panel, he would have counsel. He would have the right to an interpreter. He would have the right to gather evidence, et cetera.
Can I just throw in that we're not without experience on the review side on dangerousness. So there's at least two experiences with it with respect to the Guantanamo population, which has and parallels in the Bagram case. So on the Guantanamo side, there were what are called the ARBs, the Administrative Review Boards, and they were tasked not with determining whether somebody was detainable, but determining subsequently once a year whether that person still needed to be detained. And in a quite large number of cases, they determined that they didn't, either because the person posed no individual danger or because conditions in their countries, this was particularly salient in the case of a lot of Saudis, conditions in their countries and the creation of sort of reintegration systems allowed for the release of people who wouldn't otherwise be releasable. And so those arguments, I think, that shows that these processes aren't necessarily empty. In addition, the habeas process has produced a number of cases where district judges have said basically, this person's part of enemy forces and therefore detainable. I can't imagine that he poses any threat. Are you sure you need to detain him? And I think that shows that, when the inquiry is different, when the inquiry is about the necessity of continued detention, it often produces very different answers than when the inquiry is, is it lawful to detain the person? Does he meet the minimum criteria for detention?
Ben, would you recommend judicial review in some sort of administrative detention or law of war-based detention regime?
Well, I guess I would distinguish in this context between the law of war detentions, where I think you would want which would be administrative, basically, and I would give a lot of additional process, particularly counsel, but I do think I would, sort of retain it as an executive board matter. And then, on the other hand, the people who I don't want in the law of war detention model at all, i.e. the people who we were talking about earlier, who I would want to create a special regime for, I want those detentions supervised on an ongoing basis from the beginning by a federal judge. Back there.
Hi, my name is Raha Walla. I'm with Human Rights First. Thanks for a great panel. I guess my question is for Ben and anyone else who would be interested in commenting, and it goes to this institutional competence argument about detention rules. And you've said, Ben, I think several times and for a long time, that Congress ought to get involved in legislating detention rules, and that it's incumbent on us as a society to kind of get our hands dirty and try to figure out what the detention rules ought to be, both the substantive standards for detention and also the procedural rules. And I should just kind of say, as a kind of informational note, that Human Rights First and the Constitution Project have a paper out that argues actually that courts are doing quite a fine job with detention right now. So just to have that position out there. But I find the argument that Congress needs to get involved kind of perplexing for a couple of reasons. I was hoping that you might be able to respond. One reason is that judges are very good with rules, and whether it's the federal rules of evidence or just the day-to-day practice of dealing with burdens of proof, judges are just very good at fashioning rules and applying them and understand rules. So just as a matter of kind of technical institutional competence, judges seem pretty well positioned vis-a-vis vis-a-vis the rules and compared to legislators to fashion these rules. And another is kind of more of a, I guess, philosophical point about the role of judges and the judiciary in society. And especially when you have something like individual rights at stake, it seems like that's particularly the type of case where we would want to have the judiciary or judges involved in fashioning protections and not kind of ceding that to majoritarian whims, especially considering that, for almost 10 years now, we've been calling these guys at Guantanamo the worst of the worst. Do we really want Congress involved at fashioning substantive standards of detention in those particular situations? So I guess those are kind of my two points on that, and I'd be curious to hear what you have to say about that.
So first of all, it's good to have a face to attach to the name. I've enjoyed our email correspondence. Your point about judges being good at fashioning rules, if taken literally, proves way too much. I mean, after all, they might be good at designing a healthcare system too, but we reserve certain questions as certain developments of certain types of rules for other institutions. And so the question is really, is the broad parameters of a detention system the sort of system that you would want judges making up, or is it the sort of system that you would want democratically accountable, flawed, awful, craven legislators making up? That's in some sense a spiritual question. I mean, there's no, I think there's no convincing somebody who has an undying faith in the judiciary as an organ of justice, particularly with respect to individual rights, that there may not be the right institution for it. But let me give it a shot. And I want to give it a shot with specific reference to the paper that you referred to by Human Rights First and the Constitution Project, which was actually written partly in response to Bobby Chesney and my paper on the Guantanamo habeas cases. And our argument was that these habeas cases had showed that there were a lot of questions on which the judges were really deeply divided and greatly needed a lot of legislative guidance of one sort or another, whether it was from the legislature or from the from the appellate courts. And the two organizations got together and wrote a paper, and it's entitled Habeas Works. And the argument of the paper is that, the system is working just fine, it's producing a set of rules, and there's nothing to worry about. Now, in recent months, ever since the Supreme Court has issued, the Court of Appeals has issued Kiemba and Aladahi, I have not heard a lot of habeas lawyers or human rights groups talking about how habeas works. I've heard a lot of people talking about how the DC Circuit is eviscerating the writ as described by Boumediene. I've heard a lot of talk about the rearguard action of the Court of Appeals against habeas, but I don't hear a lot of people saying, gee, habeas works, everything's okay. And I think the reason is that maybe at the end of the day, the courts are not as friendly an institutional actor as you think to the positions that you want to protect. And specifically, I would suggest that you compare the emerging law of detention as articulated by the DC Circuit to the law of detention as written by craven right-wingers like me in papers suggesting legislative action. Because on no point is the DC Circuit friendlier to your position than I am. And on many points, the DC Circuit is much more hostile to your position than I am.
Well, not to mention that I think it was the chief judge of the circuit asked for some legislative guidance in Al-Bahani. Do we have any other questions? We've got really time for about one or two more. Yeah.
Hi, I'm Samira Daniels. I guess I can't come at this from a legal technical point of view, but having been part of the earlier discussions about the Guantanamo cases and in my reading of the Guantanamo cases by Andy Worthington, it was a very scary situation to see just the kinds of how these cases developed and what was the criteria and so forth. And in the example that you just gave, in the beginning of the Pakistani in Faisalabad, that's that's a kind of a stereotypic example. The concern I've had with practically throughout your discussions and in other forums where you've presented is this issue of racial and ethnic profiling, which and it goes to the point that Joanne made, which is that the standards are looser, and I wonder if under this administrative detention system, which I think sort of has its antecedents in the way that the military commissions sort of went through those 600 cases. I'm just conjecturing, and just from what I've heard, I wonder how can. I'm seeing, like, I see the Japanese internment, and I see, the reason I can say this is I know the conversations that are going on regarding nuclear non-proliferation and other issues, and I think that there is a lot of conflation, and there are a lot of unexamined assumptions, and I'm wondering whether if we don't get at those, how any kind of justice can come about under any of these several models.
Okay, well, let me. I'm going to try to answer that very briefly. I appreciate your concern about the ethnic profiling dimension of this. I would like to submit that the question of how you react to that depends pervasively on what your default is. If you start from the point of view that your default is a try-or-release system in which you are never going to detain anybody whom you cannot prove a criminal case against, then you're absolutely right. It amounts to a lowering of standards, and it's not much more complicated than that. That's not the default that we have, and it's not the default that I think is plausible under any imaginable political constellation in the United States in the foreseeable future. And the reason for that is not that we're craven post 9/11 terrified ninnies. The reason for that is that we have troops operating in the field, and they're arresting people in a very non-law enforcement-like context in a series of operations that really, really partake of the core functions of military operations. And so the question is, what are you comparing it to? And again, I come back to the point that I made in response to Raha's question. You know, if you compare the substantive standards of detention that is operating today in the DC Circuit, which is a preponderance of the evidence that you are part of or substantially supporting the enemy, to what I have proposed in, you know, model legislation that I wrote, which is by a preponderance of the evidence proven once every 6 months for as long as you are going to be detained, that you are A, an agent of a foreign power within the meaning of FISA, the Foreign Intelligence Surveillance Act, B, that power is covered by the AUMF, that is, it's an organization against which Congress has authorized the use of force, and C, that you, in that agency capacity, pose a danger to some other person. There's just no question that what I'm proposing is dramatically more protective than the system that we're actually operating. And so, you know, those of us who favor some significant legislative effort constantly get accused of, you know, you're trying to enshrine preventive detention in American law for the first time. Yeah, we're trying to, you know, guess what? It's enshrined in American law. We're litigating dozens and dozens of cases, and not one of them is seriously contesting the premise. And so what I say to you is, think hard about what your baseline is, and think whether the baseline against which you're comparing policy proposals is a baseline that's realistic or whether it's fantastical.
I'd just add that if you read the executive orders that President Obama issued, it addresses each one of the policy assumptions that you're referring to here, and I would suggest if you read those executive orders and follow the process that came from them, that none of those assumptions went unexamined. But what we're talking about today is a final product, or at least what that may look like. Oh, I'm sorry.
I guess I would. I think I just want to re-inject what is a great concern to me, that I think a lot of this discussion is taking place as a post facto, post decisiono, how we put that in Latin, situation where we had a task force that looked at. You're going to quote me?
Post-decisiono.
That's a great phrase.
We had a task force that basically said, okay, these guys we're going to try, and those guys get to go home, except, well, wink, wink, they don't get to go home yet. And then here we have 48 people. I mean, this is essentially the genesis of this executive order and a lot of this discussion. And gosh, we don't really know what to do with them. Okay, let's hold them. And now we're sitting here talking about whether or not, how. And so I think your point is very well taken, and other points that, okay, we're doing it. Let's make sure we do it right. We've got, a lot of really important treatment issues, but that doesn't preclude the fact that we should say, should we do it at all? While we're saying, let's do it right, like in the act, okay, as long as we're talking about it, let's do it right. But I think we also have to have like I said before, a reasonably more mature discussion about the fact that there may well be situations in which there is an appropriate existing set of principles and values that make it okay to hold somebody without charge. Law of war detention is one of those. Right now, by calling a lot of other things law of war detention, it's like a really big square peg being pounded into a round hole. But the fact of the matter is, in a lot of cases, we're saying, okay, here's the result we want. Let's create a legal justification for it. And the discussion of, okay, some of those 48 people are people that we really would like to try, but we've messed up the evidence or done other things where we have dirty hands. They are bearing the brunt of our wrong. I mean, if they committed a crime, we should try them. If we can't because of our own wrong, we may have to just buck up and have a difficult conversation with the American people and say, look, we have a set of values here. We have a set of principles. You know, we may have to face facts and release some people that we don't want to release, or we may have to try people in a way that isn't up to our, you know, at our ideal way of trying them, and we can't just have our problem be placed onto them. So I just have a problem with the sort of accepting of a result without challenging it.
Well, I think that's a good way to end this today. We've gone 5 minutes over and didn't give you a chance to get out there and eat some of that good chow. Thank you very much for coming and listening and contributing. And I think ASIL will continue this dialogue in many different ways over the next year or so. And hopefully this is one way to get it started.